Hey everybody, Greg Siskind here. I apologize. I usually kind of give people more of a reminder that we're going live at 7 p.m. Central on Wednesday nights. Hopefully, after doing this now for a couple months, people know to expect it. But I apologize if you thought that for some reason we weren't doing it tonight because I didn't say anything. We're here, and I'm joined by two of my colleagues tonight, Johnna. Well, I don't know if you guys see the same, if everybody sees it in the same order, but to my right on the screen is Johnna Main Bailey, and Johnna works on litigation, she works on employment immigration, she works on some she works on a lot of different kinds of cases. She's a real immigration lawyer as far as like actually knowing what she's talking about on a lot of different subjects. So Johnna, welcome. And Adam Cohen below me. Adam is you're mostly on sort of like on the business side of things most of the time, but you in particular, I'm excited to have Adam tonight because Adam is the author of what I think is the best treatise on immigration law as it affects universities. So it's a book called The Academic Immigration Handbook. It was written to be approachable by non-lawyers as well as lawyers. It's pretty thorough, so lawyers like it, and I think it's now on sale by the American Immigration Lawyers Association. So it's specifically being sold to lawyers, but you can also get it on Amazon.com. Anyway, so welcome for this week. I don't know what we're going to talk about. Nothing happened this week. All right, a few things happened this week. The first thing I had on my little, it's supposed to be on my screen. You're supposed to see we were trying to figure this out and we ran out of time to figure out why you're not seeing our names below us. But you can put your name in a little caption, like what your title is or something like that. And I was going to put Greg Siskind, Enemy of the People, because I feel like this past week, we're the action. Most weeks we talk about our clients and how all the threats that they're facing and the intimidation that they're facing, but this week it's actually us, unfortunately. On Friday night, and these things usually happen on a Friday night when we are going into and start what we think might be an enjoyable weekend. The White House released a fact sheet, I guess. It wasn't really an executive order. Well, maybe it was kind of. There were things that they were directing to happen, but they called it a fact sheet. And there was a section in there that dealt with immigration lawyers. And mostly it was to tell the Department of Justice that immigration lawyers have been clogging up the immigration system and clogging up the court system with all kinds of frivolous suits and all kinds of practices that were designed were designed to basically thwart the policies of the administration, and that they should punish us by filing complaints with judges and seeking sanctions against immigration lawyers in the courts, and filing bar complaints and doing all an assortment of other things. So that was interesting. I think and it was quickly followed by the American Immigration Lawyers Association. The next day issued a statement that basically said what you would expect, which is these people are just doing their jobs and the administration should move on. There was also in the last couple of days and weeks, because this is a sort of a part of we're just one player in this theme of, in this play, it seems like, of attacks on lawyers. And some of them have made the news and some of them have not. But in the same memo, they went after the civil rights lawyers, the lawyers who work on election cases. Just today, Jenner and Block, who was one of the great American law firms, very large law firm, they had an executive order issued against them. There was an order against Perkins Coie and Paul Weiss, two other very large law firms. Maybe the administration smelled blood or fear because Paul Weiss caved Perkins Coie said, no, we're going to fight. And I haven't heard what Jenner and Block's going to do. But, just in general, first of all, I mean, it's like I think for Paul Weiss, and it would be the case for immigration lawyers as well, who change their behavior on the basis of that. I mean, there's not really much point in being in existence if you're not actually looking out for the best interests of your clients and willing to, fight for them. And I haven't heard any immigration lawyers at this point say that their behavior is going to change at all. The main things I've heard are, I comply with the ethics rules and I shouldn't have to change the way I practice, and I'm not going to change the way I practice. And that's generally our statement as well, which is that we are, we're diligent about complying with the rules. We don't file cases that we don't think have legal merits. And just because the administration thinks something is frivolous, it doesn't mean that. And judges have always had the power. They don't need the Department of Justice to say the plaintiffs are filing a frivolous claim and should be fined. Just the judges are perfectly happy to pursue that, and it's a very, very rare thing, even for judges that are the most conservative judges to ever look at doing anything like that. As far as bar complaints go, good luck on there. If if a lawyer has filed a claim that is defendable, no bar is going to fine or suspend or discipline them just because the administration is unhappy about it. So that's all I think. I don't know if you guys want to add anything to that, but basically, that's where we stand. And I think this is probably the position of most immigration lawyers around the country who heard that news this week. And we are pretty proud of what we do, and we're not going to be intimidated because the administration is, feels like if they threaten, maybe they'll have fewer suits. Honestly, what I think is probably going on is they have a lot of people leaving the Department of Justice right now because they quit because of everything that's been happening in the news, and we don't have to go through that. And they are getting sued by not just in immigration, but they're getting sued in a lot of places, and their ranks are thin, and they have one of the ways to deal with that problem is to make a lot of the immigration litigation go away. At one point in the Biden administration, there were over 50,000 cases that were in the immigration courts, and those cases are there mostly about unreasonable delays. They're not, and the easiest solution for that was to actually adjudicate the cases and get things moving in a timely manner. And that's the problem that's led most of these cases to be filed. As far as the high impact cases that have been filed on things like we're going to get to in a minute, like the Alien Enemies Act, or trying to stop the administration from ending TPS programs and other things, that's definitely not going to, the lawyers who work on those cases, they're fearless. And this is going to have zero impact on whether those cases ultimately get filed or not.
Do you think that they invite some of this litigation, Greg, though, because they really want to test certain concepts like the Alien Enemies Act, right? And they ultimately hope that it gets up to the Supreme Court where they, just have that strong majority of conservative.
Yeah, I mean, I think, look, the Supreme Court can only rule on 150 cases a year, and there's a lot of things other than immigration that they're going to have to rule on, and it takes a long time to get to that. Where they sometimes get the benefit of the Supreme Court, and we might see it on birthright citizenship in the next couple of weeks, but I don't think so, is they'll get a negative ruling at a lower court, and that could take quite a while. And, like a temporary restraining order, for example, and, or on birthright citizenship, that's what happened before the injunctions. Their hope is that even if they get that kind of ruling at the lower court, that they might get the Supreme Court to reverse the TRO, the restraining order, reverse the whatever's happening at the district court, and allow a policy to take effect while the litigation is going on. And that can be almost as bad as just ruling in favor of whatever the issue is, and that's what they're hoping for with birthright citizenship, for example, where they have elevated that case to the Supreme Court, asking them to reverse the TROs in the 4 district courts that have already ruled on it. And if the Supreme Court said, you know what, we're going to let this take effect now, that will be, then, that's a huge can of worms to try and undo, especially the way this executive order was written. But that's what they would like the Supreme Court to do, is even though it might be 2 years or a year and a half before that case eventually gets to them, they can do a lot just by essentially letting whatever the policy is take effect until it gets to that point. So maybe, Adam, I don't think you're wrong that they want to test some things out. And we talked last week on this. We talked about, like, an example in Tennessee. We have a bill that's pending that wants to kick out all of the immigrant kids out of school who don't have a legal status in the state, and they know it's unconstitutional. And I went to Capitol Hill in Nashville last week, lobbying on that. What they're trying to do is get that case to the U.S. Supreme Court and see if they can get the court to reverse a 40-year-old precedent. So I think the administration is hoping for that. I have been actually relatively pleased so far with the way the Supreme Court is ruling since the Trump administration came in. For the most part, even yesterday, I think there was a decision on an issue that was a 7-2 decision. I'm trying to remember what the issue is. It's like I'm blanking on it, but I'm not so sure that on a lot of the issues that are coming up that they're going to rule with the Trump administration, just because Trump appointed those justices. In the case yesterday from the Trump administration, it was Alito and Thomas, who ironically are like the two conservative justices who Trump did not appoint, were the ones that were ruling for him, and his three justices ruled against him. And I actually think on birthright citizenship, it's probably going to be 7-2 again, with all the justices except for Alito and Thomas voting against Trump. But we will see on it. We're going to have a lot of these things are not going to get to the court this year, just because there's not that much time. When I say this year, the court finishes its session in June. So then there's nothing until first Monday in October is when they start up again. So it could be quite a while before some of these issues work their way there. I think the DACA case, I don't know if they've actually I don't think they've had Supreme Court arguments yet on the DACA case on there. So that's one that's probably still going to be next year before that happens. But in any case, we'll have to wait and see. But I think on a lot of these, really, like the Alien Enemies Act and birthright citizenship and all that, I just don't think that the Supreme Court has the appetite to try and take those issues on. And they're going to be happy probably just to let the cases stay at the lower level. But we'll know soon. I think the Supreme Court said that, the Supreme Court is supposed to have something in the first week of April about whether they're going to do anything or not on birthright citizenship in advance of the normal course of appeals. Okay. So let's talk about some of the other things that happened this week. One of them was what I was just talking about a minute ago, the Alien Enemies Act. This is really the one I think probably that I find of all the cases one of the most interesting ones, because it really deals with separation of powers in a way that was not necessarily anticipated at the beginning of the case. So basically, and you guys can tell me if I'm sort of misremembering any of this, but there's a Venezuelan gang called I forget what the initials, TDA, Train de Agua, I think. And the White House has issued basically executive orders or findings saying that there has been an invasion of the United States They've declared this group a terrorist organization, and they are using all of it as pretext, essentially, to invoke the Alien Enemies Act, which allows, during wartime or an invasion of the United States, the president to have powers to detain and remove people without going through the normal processes. And that is being claimed in the case of this Venezuelan gang. So there was a lawsuit that was filed, a class action suit that was filed in the DC District Court, and it was Judge Boasberg who was the judge. Judge Boasberg is a judge I like. He was a judge in one of our cases, one of our visa ban cases for the Milligan case. John, I don't know if you remember, he was our judge in that. And in that, I really like him because that decision quoted sections, passages from Romeo and Juliet. He's a literature lover, Judge Boasberg, and I guess he works the literary quotes in where he can into his decision, and he worked it in. And of course, it was a favorable decision for our client, so we really liked him for that. But he's a very, very bright judge. A Bush appointee, by the way, so he wasn't appointed because he had any particular left-wing agenda. But he ruled, so basically, he ruled that he wasn't buying the Alien Enemies Act as being appropriately applied in this case, and told and there was a plane load of Venezuelans that were heading to El Salvador. And they were going to be put in some supermax facility in El Salvador that I guess the U.S. helped to construct. And it was a little bit obnoxious as well from the El Salvador president, who decided to go on Twitter or X and post that, like, oopsie, they're here, too bad, to the judge. Well, that's not going to go over particularly well with the judge, who I guess, they got a little full of themselves anyway. And then Tom Homan had said, he was a former ICE director. I don't care what a judge says. We're deporting these people. That's also not going to go over well with the judge when you say, I don't care what the judge said on there. But essentially, the judge issued this order and told them, there are ICE officials on this plane. They're still under my jurisdiction, even in international waters. They need to turn the plane around and bring those people back on there, and they need to get their due process. He issued that as a verbal order from the bench, followed a couple hours later by a written order. The Department of Justice lawyer made a very risky argument to the judge, essentially saying he didn't think that they had to comply with the order because it was done verbally instead of in writing, and that made the judge angry, and that didn't go over well. But the judge basically wants to, so somebody is going to get disciplined here. I'm not sure exactly how it's going to play out, whether it's going to be contempt of court, whether it'll be some kind of sanctions against the lawyers. But basically, something I would be very surprised at this point if Judge Boasberg doesn't do something. He is methodically trying to document everything now. So he ordered the government to produce all kinds of flight records and other documentation that he needed to make sure, from a timing perspective, that everything, that the order, in fact, wasn't followed on there. They, since tried to backtrack, saying that the planes had left beforehand, or it seems like the story kept changing from the administration exactly what was happening. And I don't think they have actually brought any of those people back yet. But that's something to watch. Now, while the judge is doing that, the Trump administration appealed up, and that's the news from today. They appealed up the Judge Boasberg's temporary restraining order to the DC Circuit Court of Appeals. And it was kind of a little interesting, Johnna, because we waited like a year and a half for our decision on the in that circuit court on the green card lottery case that we had won at the lower level, and Judge Henderson was on that panel on that appeal, and we were like driving us crazy how long they were taking. So in this one, they issued a 97-page opinion in like 3 days. And I'm not finished reading it because it just came out where I just got my hands on it around 5 o'clock. But it's a really great decision on there. I mean, it's a great decision from the results that came, but it's also a really great decision to read because it's like a whole history lesson on the early days of the Republic and how the Alien Enemies Act came about and how it was initially used and what they in Congress, what they, how they envisioned that it was supposed to play. And essentially it looks like, from my quick read on it, that the decision was, there were a couple issues. Judge Henderson, she had, she's the one that had all the historical and statutory background of the act. And she was basically noting that it was intended to be for military situations. So the the wartime part of it, yeah, but the Trump administration is trying to like make this argument about invasion, and she's like, invasion has a very military kind of the understanding of it, and she interestingly criticized them for quoting a dictionary that was a recent dictionary. And she says, you should have looked at the dictionaries that were written in the early 1800s to have a better, if you want to convince me about what they intended when they wrote the statute on there. And it was, they went through this whole litany of how invasion is thought of as a very, in terms of, very military terms on there. So she said no go on there. And then there was another opinion that was written by Judge Millett, and she talked about basically the due process requirements under the Fifth Amendment and the need for judicial review of the proclamation's implementation. So they each went at it from a different angle. Judge Henderson went at it just from the plain, about the Alien Enemies Act itself and what was supposed to trigger it. And then the other judge was basically focused on saying, well, even if it is triggered, there's a right to judicial review by anybody that is that's detained under it. And so that was interesting. There was a third judge on the panel who dissented. His argument, he didn't say actually that he basically, I mean, I think he's probably the one that the administration is the closest to the administration's view on it, but he did say it was a jurisdictional thing for him. I think it's kind of a weaselly way to get out of it, but basically saying they should have filed the case in Texas, I guess, where they were detained before they were sent to El Salvador, and they should have been done as habeas claims or something like that. But anyway, that's the breaking news from this afternoon. Now, what's important is I think from the standpoint of the substantive immigration law and whether this Alien Enemies Act can be used, I mean, it's usually important because I think the administration really was hoping to use it in a big way. Their goal has been to keep people out of immigration court and get them out of the country as quickly as possible without having to have them go through a judicial process, having to go through court. So they really needed this act to be interpreted in the way that they wanted in order for that to happen, because there is a problem that started many years before Trump came in. It's a continuing problem, which is that there's 4 million cases in the immigration courts, and the administration, I think Biden probably did more than most to try and expand the number of immigration judges in the country over the last couple of years. Trump didn't do that in his first term, and he already started out in the beginning by firing 20 immigration judges like in the first week. So they got a big problem. If people are put into immigration proceedings, they're going to either have to get a lot of judges, or they're just going to have to wait it out. And it could be, 8-10 years before they clear through the cases that are already there right now, much less all the ones that they want to eventually get there.
I would have thought that's where they wanted the big government to be. Like if there was going to be any big government, that it would be with immigration judges or, increasing ICE, which is probably still a possibility, but
Yeah, I mean, I think honestly, the part of it that I think that if they want people, I mean, they want people to self-deport.
Mm-hmm.
That is their big thing is like, well, if we can't get rid of them, through the legal process, maybe we can talk them into leaving on their own, and then that we'll get what we want anyway. And so you might notice, I noticed the other day on MSNBC, not exactly a conservative channel, that Department of Homeland Security was running ads encouraging immigrants to self-deport on there with Kristi Noem, the DHS secretary, basically like, we're going to get you, so you should leave on there. I mean, it's basically the message. And I know they have billboards in all kinds, foreign countries right now trying to encourage people to self-deport. So all that's going on. They have this new, well, we'll talk about it in a second, registration, which is going into effect in a couple of days. I think that is part of sort of a psychological warfare where they're trying to get people scared enough that they will just leave. And they won't have to actually deport them. But detention is the other one that is really, I think, what they are trying to use. I mean, they're trying to get money from Congress. They're trying to divert a lot of resources from other agencies into expanding detention capabilities, taking sort of abandoned prisons, all kinds of places, army bases, and make them into these big detention centers. And that will be, probably as far as, and then putting the squeeze as much as they can on people being able to work legally, and hoping that people will leave. And whether that's going to be successful or not remains to be seen. But I don't think that they are going to have the capacity to really expand in the way that they would need to actual removal proceedings themselves, unless there is either some abandonment of a lot of the due process rights that exist in the courts. They tried last time to have quotas on judges to try and get them to move more quickly. There's all kinds of things that they would like to happen to speed things up, but they still have 4 million cases to work through. And that's not even the new cases that started, since January. So we will see. But Johnna, why don't we talk about registration? Because we talked about it a few weeks ago when it was announced. Now we actually have a form that's been prepared by USCIS at uscis.gov. But can you talk a little bit about what registration is? And what the penalties are for not registering, and who has to register?
Sure. So the registration goes into effect April 11th. So we have a little bit of time, meaning if you're considering registering and you're required to register, one strategy would be wait till closer to the date to see if there is any litigation. This is not an entirely brand new concept, meaning the idea of registration has been part of the immigration regulation, but there has not been a means to register. So in that sense, that is what the Trump administration is doing, is providing the means and making it mandatory. So the language Greg referenced in advertisements, that is now the banner across your USCIS account. It is not friendly. It is saying, you can register or you're welcome to leave, and you can do that. That is always an option. Again, not really the welcome to America most immigration attorneys would prefer our messaging be. So registration is aimed for those who do not have or have not had prior contact with immigration, meaning the people who are exempt or do not have to register are those who already are permanent residents. They're not part of this program at all. So if you are a green card holder or permanent resident, this is not touching on you or your case. Similarly, if you've ever applied for permanent residency, even if that application was later denied, you're not subject to registration. People who have had removal proceedings opened against them, meaning there was a notice to appear, even if this was an old case 20 years ago and you were ordered removed and you're still in the US, you are not subject to registration. If you've ever had an employment authorization document, an EAD, also known as a work permit, you are not subject to registration. The common theme throughout all of this is that you've applied for a benefit and been fingerprinted. That's not the language they use when they're talking about registration, but that's the theme when they're explaining who is exempt or does not have to register versus who is required to register. So if you are a DACA holder, a TPS holder, and have EADs attached to those statuses or for DACA deferred actions, you're not required to register. Meaning the people, sorry, did you have a question, Greg?
Yeah, I just also want to know what they're asking for in the registration form.
Yeah, so they're asking for address. I have not reviewed the form like Greg has, so maybe Greg has more details on that besides
I mean, it's still a mystery, I think, to a lot of us as far as what they're going to be asking for. But I don't think they're asking for like a lot of details about status, are they?
No, I think it's I am registering an address where I am physically living on a day-to-day basis.
Right. So that is interesting. That as far as them figuring out, if they're going to be using this, is basically we're going to target people that register and go and pick them up and all that. That's interesting that there's not a lot of information on that, that's being covered. And a lot of people don't even actually, that's kind of a whole can of worms because a lot of people aren't even like really clear on what their status is. So I'm not sure that they would have such an easy time describing it without talking to a lawyer.
Exactly right, Greg. So it's more than interesting, it's concerning because it's a little bit of a catch-22. If you are without status and don't have a means to apply for an application later, you're effectively coming forward and saying, I'm here, here's my address. If you want to initiate removal proceedings, that's the information you need to do so. But the consequence of not registering is that you could then be inadmissible or ineligible for
Right.
benefits in the future. So I think that's the balance and the conversation people need to be having with attorneys to figure out.
Yeah, I mean, and also a lot of people that are, I mean, I'm wondering how this would affect a cancellation of removal request as well. That, if you eventually end up in immigration proceedings and you're eligible for cancellation of removal, I mean, you have to show that you have to pass a character test with the judge and show them that you are, a good person who deserves it. And my guess is that the ICE attorneys would probably use the failure to register as a, to show that a person is not, doesn't like to comply with law on there. So I'm not sure that, how it would affect those cases as well. But it's I think people have to make their own decisions on it. And as immigration lawyers, we are never going to encourage people to violate the law. And to the extent that this is the law, and I guess there is at least one legal challenge against it. But for right now, this is the law. Our advice has to be, this is the law, and you are expected to follow the law. But it's a misdemeanor, but it has consequences. Misdemeanors, I think a lot of times people think is a slap on the wrist. You can be jailed for a misdemeanor for a period of time, and fined, and potentially suffer immigration consequences. So I think people have to consider all that. Also, the other sort of twin news of this is the IRS news. Which, over the years, the IRS has always encouraged people. It's like, you should get an individual taxpayer ID number and file your taxes. We don't share information with the immigration agencies. And the IRS always had one goal and one goal only, which is to maximize the amount of money that it was collecting on behalf of the American public. It was the tax collector. That is their job. And now, with the politicization of everything and and sort of this seeming breakdown of the entire federal government, it seems like all agencies are bending to the ultimate, opinions of the White House. And they have announced I guess Monday, maybe an agreement with Department of Homeland Security on how they were going to be sharing information. Though, that has also a lot of information on people's whereabouts as well. And also, if you file under an individual taxpayer ID number and you don't have a social security number on there, it's not a big leap to sort of guess why the person did that. It's probably a fairly reasonable, educated guess in most cases that the people that do that are doing it that way because they don't have a legal status on there. So it seems like there's a lot of ways the government could find somebody if they want on there. Not to mention, all the other things like, if you have kids in school, kind of watching, following them home, and a million other things to figure out where you actually are on there. I think at the end of the day, for a lot of folks, there's going to be safety in numbers, and all, where the administration is trying to scare as many people as they can by imposing, those kinds of requirements and saying, we know how to find you and we know where you are, and we've been on there, and then just hoping people will leave, as opposed to people staying and getting their day in court and asking a judge to give them relief when they eventually get into removal proceedings. Because a lot of people that are without status do have relief if they get into proceedings, or they might have an asylum claim, or they might have a lot of other things that will give them relief eventually. So that's that. Johnna, I'm going to turn to Adam, and then we're going to come back to you in a bit to talk about travel bans and legal immigration issues and that subject. But Adam, you're going to talk about the other, one of the other big stories that's in the national news right now, which is how students are being impacted and universities are being impacted by the agenda of the administration right now. So maybe you can talk a little bit about some of the broadly about, not about the individual cases, but broadly what we've been seeing in the news, and maybe talk a little bit about how what people need to know.
Yeah, and I think it kind of dovetails a little bit with what you were saying about the Alien Enemies Act, because there are other provisions that are kind of being dusted off as it pertains to students and to initiating removal proceedings. And I think it also intersects well with what Johnna is going to talk about, about just difficulties at ports of entry and things related to to coming travel bans and those types of considerations too. I mean, a lot of this it's emerging from the executive order, the Combating Anti-Semitism executive order, and it charged agencies with just further investigations related to what is happening, particularly on campuses. And that's why you really see, students, and you see some scholars, right, some faculty that are kind of caught in the ambit of this as well. There's a provision that they're using in removal proceedings, or to charge in removal proceedings, which is, basically it's these 212A3 grounds, which are all security related grounds. And one of them is related to proposed activities where the Secretary of State has reasonable ground to believe there would be this serious adverse foreign policy consequences for the U.S., right? And basically there's an exception to that, where it shouldn't be based on that person's past, current, or expected beliefs, statements, or associations, right? Which is, you shouldn't necessarily be treated this way because of viewpoints that you have. That doesn't necessarily mean that there are adverse, foreign policy aspects to this, unless the Secretary of State personally determines that the alien's admission, the individual's admission, they use the word alien in the Immigration Nationality Act, the individual's admission would compromise a compelling United States foreign policy interest. So it kind of allows, in that sense, the Secretary Rubio to make personal determinations, related to these individuals posing a compelling foreign policy interest. And I think that that's something that we're going to see probably litigated as well. But it's another one of these policies. It's been very rarely, or grounds, right, that have been very rarely used historically. But it's part of the administration's attempt to try different things. And another thing is just if we kind of back up, right, there is this twin aspect of visa revocation that's happening right now, and also then placing these individuals or detaining them and then probably placing them within removal proceedings thereafter, right? At least due process would indicate that needs to happen. And so there's very close collaboration that's happening. And when they kind of pull out these, they revoke the visas, they can then put these individuals, these students, into removal proceedings by saying that they're present in violation of the law. And I don't remember, Johnna, I know you practiced in immigration court a lot more recently than I have, but I remember the present in violation of the law ground, but I just don't remember that there was such a, just presence of using this type of ground, like coupled with visa revocation into these removal grounds. And I think part of it is also just they indicated that, there were a lot of people that were arrested. I think they were kind of reviewing certain cases, and they said that there weren't any visa revocations that occurred following the arrest. So it's something that they lament from the Biden administration, and were very active, are becoming more active in doing this now. So those are just kind of a few things to put on the radar. And I know that there's different ways that they are searching for students and searching for these activities, that these problematic activities that they talk about in the Combating Anti-Semitism memo. And some of them are related to just arrests and people who are already in the criminal justice system. They're using AI. I don't know if you have any thoughts of this, Greg, but say they're going to use AI. And of course, there's social media searching to try to find people through articles and, I guess, media appearances and things of that sort. And they can
the dicey thing, yes, they're doing it. Like Johnna's going to talk a little bit later about phone searches and such, but they are, they're looking at people's phones. They're looking at people's posts on social media. It's supposed to largely be about support of a terrorist group. That would be the most likely ground that they could use for the, for the
adverse foreign policy interests.
Right? Yeah. So it's a little bit, I kind of, we try and avoid, trying to take positions on Middle Eastern issues here, but it seems like I always cringe a little bit when you saw the anti-Semitism executive order, because it is very clear, I think, what the administration is trying to make that as a kind of a useful way to couch what they're doing, when it's a lot. It has a lot, and there's a lot of aspects to it that have absolutely nothing to do with anti-Semitism, but everything in the name of that sort of cleans it up for them as far as their acts. And I know there have been a lot of members in the country's Jewish community that have been very vocally outspoken about the arrests that have happened over the last few days. So we're not going to get into that, but I will say, I think that they, once these cases actually get to court, for a lot of these folks, when it's just basically taking a position on what's going on in that region of the world, as opposed to actively endorsing a group that's labeled a terrorist group and all that, there's a wide gap potentially for a lot of these people, and I have a feeling that the judges are going to. In a lot of cases, are going to reverse course. Reverse what we've already seen. We know, at least, with student visas, there's a lot of discretion at the consulate and things. And there's no appeals process or anything like that. But you do have more rights once you're here,
right? And they're entitled also to have, if there's a visa revocation and the person is present in the U.S. and they get put into removal proceedings, they have the opportunity to contest, that present violation of the law allegation and look at that underlying, the underlying visa revocation. So I would note, I mean, yeah, and I say it's complicated.
Permanent residents have even more rights
issues.
As far as and
Yes.
permanent residents it is very hard to strip somebody of their permanent residence and remove them without giving them substantial due process as far as the ability to defend that. It's it's different when somebody is seeking to re-enter the country from abroad. You have fewer rights at a port of entry, but for somebody who's actually in the United States, to try and strip them of their permanent residence without any actual criminal activity, that's something I think judges are going to have they're going to have a lot of time, a hard time with that.
So that aspect, but I'll just add just a couple of other things that maybe students aren't really thinking about, when they're kind of looking at these issues of individual, students kind of getting picked up and kind of caught in the crosshairs of this situation. There are ways that the administration is really coming down on universities in general, right? Like, withholding funding. We saw this in the case with Columbia University, right? Withholding funding. Putting a lot of pressure on universities. There were letters that were sent to there was a letter sent to 60 universities, just basically saying that there were, Title VI violations.
My undergraduate and my law school institutions got those letters.
And I'm not going to say all the names of the universities, right? Because there's 60 of them, but I think that, it raises the question of, one of them's Columbia and one of them's Brown, right? And we've already seen that there were students or faculty that were in these situations. So it is, the administration making an example out of these, universities and student and perhaps faculty populations. So it's something to think about, that there's, it's beyond just the student, individual student issues. The only other thing I'll say is that the Student Exchange Visitor Program, they have field representatives that are helping, assisting, providing guidance to universities in, compliance with the regulations. FJ&M, students and exchange visitors among the most monitored categories in the entirety of the U.S. immigration system. They need this type of guidance. And, my understanding is that these SEVP, reps and sort of that infrastructure will be changing from that cooperative, largely collaborative relationship to helping, together engage in this compliance to something more enforcement related. A more enforcement related function. And I think that will really quash a lot of that dialogue that the universities have with their field representatives.
Yeah. Let's change. Let's move the conversation to something somewhat related. And John, I guess there are two things I want you to talk about. First, one thing first and one thing after that. The one thing first I want you to talk a little bit about is, I've been, had some interviews this week. I've had a lot of people contacting me like, can I travel? Is it, is this a bad time to go out? We know that there was some news about travel bans that are coming. I want you to talk a little bit about that, as well as this issue about phones. We can screen share if you want on that client flyer that the American Immigration Lawyers Association put out. I wanted you to talk about that, and then I wanted you to talk about the news on the CHNV parole program, and then after that we'll start taking questions. So while you're talking, I'll see if I can figure out how to upload this document. You're muted. We're not hearing you.
I'm not.
Oh, now we're hearing you.
Starting to hear you. I think there's a little feedback, Johnna.
Okay, I don't know what the feedback's from, so I'm sorry.
Right.
Is it too obnoxious for me to talk, or am I okay with my mic?
Maybe to turn it down a little bit and get closer.
Okay.
See if that helps.
I got too comfortable. Is that better, guys?
Yeah, no, it's squeaking a lot. So I can, Adam and I can probably,
I can give you banners. CHNV is no more. Find alternatives and find them quickly.
Yeah, so it's no more until a judge says it reverses it. So the CHNV, that's Colombia, Honduras, Nicaragua, and Venezuela.
Cuba,
Honduras, Nicaragua, and Venezuela.
yes.
Okay, and then
No.
Colombia is in a different program.
Yes.
That program is also, I mean, so there's basically 9 countries that are in the various humanitarian parole programs. Ukraine, and then there's Haiti and Colombia and Guatemala and El Salvador, I'm thinking, are in one program. And then the CHNV, the Cuba, Honduras,
Haiti.
Cuba, Haiti, Nicaragua, Venezuela.
Nicaragua, Venezuela. We'll
Right.
get there.
So I apologize. It's hard to keep the acronym right, but they had all those programs were suspended as far as new entries pretty much right off the bat when the Trump administration came in. Now they are trying to pull those, to basically end those programs early and force people that are in those programs to either leave the country or be out of status. And they want them to, for a lot of people, they've given them 30 days. People are, going to need to scramble to figure out what they want to do between now and then if they want to stay in a legal status. So people will presumably be filing asylum. In some of these countries, they'll be filing asylum applications or looking at other benefits. In the meantime, just about every action like this, after there's an announcement, within a couple of days, there's a lawsuit. So people that are in that situation always need to be working under the assumption that nothing's going to happen as far as stopping them in the courts and coming up with a strategy in that case, but also being closely monitor what's happening in the courts to see. And there is actually there's a really good website, by the way, called the Immigration Policy Tracking Project. It is, I'll see if I can put this, it's impolicytracking.org. I'll try and put that into a banner before we're up, but it's a good way to kind of see all of these cases and what's happening, and a good way to track all the policies that are being pushed out so much. And sometimes you forget about one because so many other ones have happened since. But I expect that one to be challenged. They didn't, have much of a notice process on there, and they told people coming in they should expect at least a certain amount of time. Anyway, with all that being said, I'm expecting those cases to be filed probably like the Trump camp filed everything in Texas for a specific reason. Cases are being filed in other jurisdictions against them. It was a little ironic that they were complaining so much about activist judges and all that when America First Legal Action, I think was the name of the Stephen Miller founded, that they basically made a complete specialty of suing only in one jurisdiction in Texas that was a virtual lock that they were going to get the decisions that they wanted. So I guess their medicine, they're getting a little taste of their medicine. But that's so we'll have to keep an eye on that. But people that are in that situation need to get counsel immediately to talk about what their options are. Sometimes there are no options. Sometimes there are several options. But you should talk to an immigration lawyer about that. And it's just generally a good idea, by the way, not to rely on stuff that you see on live streams and social media and all that as your sole source of information on what you're going to do with your own immigration plans. Always talk to somebody who can really dig into your specific background to see what your options are. So I haven't changed the banner since we started talking about that. But the other thing that we're going to talk about is travel.
My mic situation any better?
Yes.
It is. I've done nothing. Okay.
Okay. I don't know. What was
I guess it's my time to talk.
Yeah, so let's talk about travel. First of all, let's talk about the travel bans and what we know about what might be coming.
Yeah, so if you have not already looked, there's effectively a color-coded system of how we will consider entry based on country of origin. So there's kind of like 0 entry list of countries. There's probably not going to be entering. So all of these basically set itself up for like when we had travel ban waivers available really all through Trump's first administration. We don't know what that looks like yet.
I'll take that.
Oh, and this is you're ready. You're
ready
for my next topic.
I'm ready.
I think the difficulty with travel ban is we don't know the date this will come into effect. So just
we think we know what countries though.
Right.
That's like, and that's very different than what we saw the last time because
that's true.
43 of them versus like, a half a dozen.
And I want to be clear on who is subject to these in terms of my inbox, like Greg's, is full of people asking about travel. So green card holders are not necessarily subject to these travel bans. So to the extent your residency has already been approved and you're considering travel, your travel and your likelihood to be admitted or returned back to the US in permanent residency status is much more, not guaranteed, but more likely. You are afforded more deference to your status than those who have visa holders. So to the extent we're hearing like difficulties of people coming in the airport, residents who have new criminal activity or new perhaps associations with certain kind of protests, those might be conversations you want to have with an attorney. But if nothing has changed and your travel is, you have a trip planned to Canada, I'm not discouraging those. If you are a visa holder and perhaps listed on one of those countries and have upcoming travel, maybe you want to strongly consider rescheduling that trip, knowing that reentry is not guaranteed, especially if you're on the more elevated list of 0 entry. Okay. So Greg, I don't know if you want to switch screens. If we don't have much time, I'm also cognizant of that.
In terms of these lists, the red countries are the ones that are probably going to be hit the hardest. Most of them are like the countries you'd expect, like Iran. I mean, the countries that were on there the last time. The big one is Pakistan. Seems to be the big surprise for me because so many skilled workers come from there. So that's one I'm particularly concerned about. And also I'm not sure if it was on the red list or not, but it did surprise me that Russia and Belarus, which are supposedly, Trump friendly, were also on the list. And then there's a bunch of countries like Vanuatu. I don't know if that's how you pronounce their name. It's like, why are they on there? Well, first of all,
I think some of the reason for that is some of those have eligibility to basically invest into citizenship. I was reviewing that where a client had asked about getting citizenship to an alternative country to be exempt from the travel bans. And I was like, ding, ding, ding. I'm recognizing similarities in the list they were asking about versus what's on the travel ban list that I did not understand either. And then I was like, oh, this makes a lot more sense.
Right. Well, I mean, there has been a lot of news about people who are, sometimes they're just tourists that are coming from countries that are heavy tourism countries like Germany and the UK. And then there are people that are coming in that they're having issues with once they start getting questions especially about their political opinions and such. So I wanted to talk a little bit tonight. We really haven't talked that much about phones and electronic device searching and like what that's all about. And the American Immigration Lawyers Association put together a very informative client flyer. So you should ask your immigration lawyer about this to get that, and let if they have their own they may have their own version of it. But I'm going to add that. I'm going to take off the banner so it's easier to read. And Adam, that's why we were laughing, but we were chuckling before because we couldn't figure out why you couldn't see our names. And it's because when I put a banner up, our names disappear. I don't know why that's the case with StreamYard, but maybe I'll figure that out for the next time on here. But Johnna, this is the flyer. But maybe you can, we don't have time to go through all this stuff, but maybe talk about a couple of bullet points of some of the most important things to think about.
Yeah, I think the big takeaway is when you are entering the US, your electronic devices can be subject to search. So knowing that and knowing, what you have looked at, what you have downloaded, may be reviewed by an immigration officer to consider your admission or denial of admission into the US can be really, really important. I think this is a great tool. So if you have further questions, that's really helpful. If you're in a position that you can have separate devices and have like a more stripped and very basic traveling device, that might be the safest way to go. And that, I think that would be true even if you're not concerned about an inadmissibility issue, but maybe you have like sensitive data that you're doing for your employment that's on that device. You probably don't want that shared with a government agent. So when you're considering travel, just be mindful of that, mindful what devices you're bringing in, mindful of what is on that device, and trying to limit access either through passwords or encryption to protect yourself and whatever data is on your devices.
Or keep things in the cloud and take a flip phone.
Yeah.
On there. There's less to search if you're on that. But I've had people ask me, can I just have posts on there that basically are like, just critical of the administration and their policies and et cetera. Do I have to worry about that if I'm not even getting into like these issues that have been in the news on the Middle Eastern politics and all that? What if I just have I think Trump's an idiot, post over and over again on my social media? Should I worry about that when I'm coming in? And I know there's sort of like the answer to that should be absolutely not, as far as like in a real democracy that shouldn't matter. But I know you're kind of making, sort of like a little a face that you're, like, I don't know, on there. I mean, it's not professional, obviously, for CBP officers to do that. And there have been obviously a number of instances in the news of examples of CBP officers not being professional. Mm-hmm. I think that is, hopefully not the norm on there. But how do you answer that question?
Yeah, I think that question for me has evolved over time. And I think previously I would say keep all your stupid political banter up. I think that's great, whether I agree with it or not, right? That's part of the beauty of our country, is being able to express oneself. Probably like you, Greg, I think since the new administration has demonstrated how strict they can be, then I would probably think it's advisable to be pretty stripped down on public facing platforms that may be reviewed at your entry to determine whether you can be let in or not out. That's probably a conservative approach, but I don't know. What do you think, Adam?
I mean, I agree. I mean, I agree with both of you because you're in such a vulnerable position, at a port of entry. You're in a vulnerable position where a consular officer is making a decision about you, about whether to issue a visa, right? So it wouldn't be the same thing if you were not planning to ever travel internationally. But, I mean, the reality is that, people travel, right? And that's kind of the issues of the ports of entry and at the consulates, with a lot of discretion to make decisions.
All right, let's jump to some questions. So let me remove that. All right, we're back. That worked. And we have several questions on here.
Can you remind people just who they would like to post a question, Greg, but they're not quite sure how to do it?
Oh yeah. So basically, if whatever you're watching, if you're watching it on YouTube, you just post a comment like you were commenting on a video on YouTube, and it'll show up on our. We see a stream here. If you're on LinkedIn, you just comment on what you're seeing on the live stream there. Same on Facebook I think those are the 3 channels that we're on. Okay. So the first question was, are there organizations filing cases against the actions we were talking about before? Yes. And I promised that I was going to, so the impolicytracking.org. So I'm going to post in a second, I'll put it in a banner, this website, impolicytracking.org. That is the website where you can go and see. Yes, I spelled it correctly. You can go and see a good rundown of everything. They also have a complete history of the first Trump administration. So if you kind of want to see things that were being, the last go around and compare it to this one, that is a good address to write down, and you can see who's suing on what and what the new policies are that have been issued. So I'm going to go back to questions, and okay. So this is a question about somebody, if somebody's undocumented and they have been here for a lot of years and they're picked up by ICE and put in deportation proceedings, what are 2 or 3 common things to potentially avoid removal? So one thing that we have been advising folks about is, let me get rid of that banner too. We've been advising people, if you're in that situation where you've been here for a long time, and it's important that you get put into removal proceedings versus being removed expeditiously. Expedited removal is when the government just basically puts you on an airplane and sends you out of the country, and they can do that if you've entered the country without inspection and you've been here for less than 2 years. And they are doing that to a lot of people. Problem is, there are a lot of people, the burden is really on the immigrant. They are not going to do the research to figure out whether a person has been here for more than 2 years or not. So we've been advising people to always have with them documentation about showing that they have been here for several years. If you've been here for several years, you should be put into removal proceedings. Once you're put into removal proceedings, you have rights, you have due process. You may be, as we mentioned earlier on, may have the ability to seek relief with the judge, maybe asylum, maybe cancellation of removal, or you might have a qualifying relative who might be able to file for you. There might be different ways that you can pursue it. So that would be one thing, is that. And the other, I think, is to probably at least check with the lawyer periodically to see if there's any relief available. And I think for a lot of people, they're sort of, they haven't had that conversation, and they might be missing out. And then also, I think people should need to think about, if I do get picked up, do I have a plan for my family? And a lot of people, they don't, and then they're in this crisis situation where kids may be separated from their parents. Parent might be moved to a detention center far away. So it's not there's not an easy set of answers, but those are a couple things I can think of. I don't know if you guys have anything you want to mention.
One thing I will add, outside of removal, but can be done at the same time if someone is also in removal proceedings, is a U visa, which is for victims of certain, usually violent crimes, including domestic violence, aggravated assault. Those can also be things like kidnapping or sex crimes. So and then T visas, which is available for victims of trafficking. So if you've had a bad employment situation or sex trafficking, or if you don't know and you need to talk with an immigration attorney to kind of alert them to this fact scenario so they can help you decide if that's a trafficking situation, that would be helpful to know, because those are both independent ways of applying for status. Can be done when you're in removal, but also outside of removal proceedings. So that's a common consultation appointment, just to say, hey, this is my situation. Am I eligible for anything?
Yeah. All right, we're going to move on to another question about TPS. We kind of alluded to this before, but the TPS program is being revoked early, which I guess is the case now for Venezuela and for Haiti. I don't know if any other TPS programs have been, they've tried to end them early, but we know that. We know the parole programs. And the question is like, is there any hope with the courts? And the answer is yes. On TPS, one of the things, and if you go to that immigration policy tracker site that I was talking about before, that happened in the first Trump administration, was there was an effort to end the TPS program for, I believe it was El Salvador and Guatemala
And Honduras.
and Honduras. And the Trump administration ultimately failed on stopping those programs because while presidents get a lot of discretion to put a country into TPS, removing a country from TPS, you are only supposed to do it if you can show that country conditions have changed such that TPS is no longer needed. And the Trump administration is going to have to convince a judge that conditions in Haiti and Venezuela are great, and that these people can all go back safely and they have nothing to worry about. The reality we know is very different from that in both countries.
Department of State says that with their travel.
I mean, that will be used. It's like if you're warning Americans about going there, the Trump administration is trying to kind of claim we're on a war footing with Venezuela so that they can advance their other policy interests with the Alien Enemies Act. But at the same time, they're trying to not say, they have to say that we don't have any kind of conflict with Venezuela and it is safe for these people to go back. They're going to have to embrace their contradictory positions, the Trump administration, if they're going to have any hope here. But I'm feeling like the plaintiffs in those cases have a pretty decent chance of having some success, and that those programs are not going to end on the days that the administration is saying that they are.
You said TPSers, if you are working with an employer, you should be doing your effort now to be asking your employer if they would be willing to sponsor you. People with TPS have a lot more flexibility and options in terms of employment-based immigration than other humanitarian status like DACA or asylum seekers. So that's something you should be exploring now while your TPS is still intact.
There were some questions that were asked about registration. I'm going to show one, and then I'm going to show the next one. This one is like, what's to stop the government from sending a deportation notice? Mm-hmm. What are you advising clients who can't change status now but might have a chance in the future? And then there was that question on the 485 for somebody who might be applying later on about, have you committed a crime that you have not been arrested or convicted on? So, Johnna, what do you think on those questions? We're first on the first question about what could the government do with that information? Could they send notices to appear to everybody that files? I guess they have to have some basis to know what their status is. You can't. All they have is an address and a name. So they're going to have to make some kind of do some kind of research into the person's status in order to be able to figure out whether they are subject to removal or not.
And another part of that, as I mentioned, registration is targeting those who have not been fingerprinted. So I think for me, understanding registration, the question mark I have is, will it eventually involve some kind of fingerprint, or we have questions on your registration? These are all things we don't know yet.
They might call people in for fingerprinting, in which case, that's the same thing. I mean, I'm not sure what's going to happen on that. That's a lot of people were talking about. I know anecdotally there have been some instances where people that had already been ordered removed that are under ICE supervision. Some of those people, they have to come in and report, and some of those people have been removed. We know that. But those are people that had already had removal orders, which is very different than somebody coming in for a fingerprint who's not ever been in proceedings. Can they potentially be put into removal proceedings? I suppose they could. And then they would start that 10-year wait eventually to get their day in court in front of a judge or whatever period of time it's going to be. But there are a lot of unknowns here, and that's part of what is the risks here as far as that goes. But the other question is right. If you haven't registered and it's a misdemeanor and it's upheld in court, that program, and you don't answer that question on the adjustment application, you could have a problem. I think an adjustment on there where you have a criminal history that you've admitted to, and you don't really have much of a choice in the matter, the way that question is asked. So I think that if you have a possibility of adjusting at some point and you don't register, I think we get a Democratic administration down the road. Maybe they'll be interested in being more forgiving and thinking that the whole registration program was garbage. But in the meantime, that's probably what's going to happen, is that they're going to.
That question is unique to the I-485. The failure to register is also an independent ground of inadmissibility. We use that term inadmissibility, meaning a problem to later obtain status, whether that's permanent residency or a non-immigrant status. Even if you are in process to ultimately consular process your permanent residency, I think it's wise to register to ensure you're not setting yourself up for a process you can't complete because of this new ground of inadmissibility for failure to register.
Yeah. This person also asked a question in which I don't know if we talked about this last, but this has been in the news about trying to reconfigure the CBP1 app as a way to basically, I guess that to get people again to self-deport. Do you guys know what I'm talking about with that, with CBP1, or maybe not on there, but that there has been this effort to just reintroduce it for that purpose and not as a way to help people get appointments to actually seek out and file an asylum application. So I'm going to move on from that question, but that's more of a comment. That is a very specific question in person. All right, so I'm going to actually leave it there because we actually are over on time. So it is it's 8:18. We missed our target of trying to keep it to an hour. But I want to thank you guys for participating tonight.
Great.
We will be back next Wednesday, where I'm sure we will be shocked by another 7 days in the news cycle with immigration. But I thank you guys for watching tonight. I hope we were helpful, and I think we cover a lot of issues. And anyway, until next Wednesday, everybody stay good. Bye-bye.